Welcome back to the Reidel Law Firm YouTube channel. Today I want to chat about spousal guarantees in franchise agreements. This topic comes up fairly commonly, fairly often. It's something that is important to consider and think about, but frankly, the answers are challenging because it's going to depend a lot on your state that you're in, right? The state that you are a resident of and that you're doing business with them. So let's chat about spousal guarantees. What is a spousal guarantee? Spousal guarantee is a personal guarantee that is signed by the spouse of a franchisee, right? So if you have a husband and wife team, the husband signs a franchise agreement. The wife is not necessarily involved in the franchise business and does not want to be a party to the franchise agreement. So they're not, the wife is not signing the franchise agreement itself. But some franchise systems will require the wife to sign a personal guarantee or a spousal guarantee. And usually this does several things. It will give the spouse's personal guarantee to the franchise agreement in regards to damages and payments and fees, anything that the franchisee is unable to complete, right, or meet their obligations to. Second thing it does is it will usually also have a non-compete on the spouse. So the spouse now is also barred from being involved in a competing business as the franchisee. And there may also be confidentiality requirements in there that the spouse will maintain confidentiality of anything learned through the franchisee. So that's what a spousal guarantee is. And they are fairly common, I will say, in the franchise industry. If I had to guess, I would say probably 50%. In my experience, 50% of franchise agreements will probably have some form of a spousal guarantee in it. So it's something that you're going to come across in the franchise industry if you're looking at different concepts. Now, the legal impact of a spousal guarantee can vary. It could have no legal impact, meaning that it's meaningless. Like in the state of Texas, where my law license is, it's essentially meaningless. And I'll explain why in a minute. Other states, it could make all the difference between your spouse and your spouse's assets being up for grabs in a potential conflict or claim that the franchisor has against your franchise unit. So it really varies. So I'll explain. In Texas is what's called a community property state. Anything owned by one spouse is jointly owned by both in the marriage. There are very specific exceptions to that. There's well-developed case law and rules around that. So it's not that's the general rule of thumb. It is not always the case, but in probably 98% of the folks that we work with, small and medium-sized businesses, that is the case. Anything that you own in the marriage is owned by both. And what that means in a community property state is one spouse can sign a franchise agreement or sign a personal guarantee or sign a credit agreement or something, and that obligates all property of the marriage of both parties to be potentially liable to that claim, right? Or to whatever that agreement they're signing. If they're having if the personal guarantee is in there, the property of the marriage could be at risk, depending on the circumstances. But in Texas, there's no difference, right? There can be, but almost certainly you're not going to have a situation where the wife owns this and the husband owns that. It's you both own all of it, right? And when a husband signs a personal guarantee, that means that creditor can come and take any property of both parties. So it's when I say that in Texas, spousal guarantees don't usually matter because it has no impact, it's because one party signing that personal guarantee probably is going to obligate all of the marital property, unless you do very specific things and you know what you're doing and you've set up an estate plan or something to create separate property and to maintain separate property. If you haven't done all that, then 100% the community property is owned jointly, and one spouse signing the personal guarantee obligates all of that community property. So that's on the end where it kind of doesn't matter because it's always all of the property will be up for grabs by a creditor. On the other range is states that have It's called equitable distribution, and the other is tenancy by entireties. Honestly, I'm not even sure which states follow that anymore. But what that means is that they have well-developed rules around who owns what in a marriage. It's not all owned together necessarily. It's owned separately, with certain caveats around how it can be used and whatnot. So in those states, honestly, I don't think there's very many left, frankly. But it's not my area of law. I'm a franchise attorney and trade attorney, so I don't know this specifically. But I'm just giving you some color and context in a franchise agreement. It's my point here. But in those states that follow those rules, having a spouse sign the personal guarantee would then obligate their wealth, right? Their assets. If the spouse does not sign that personal guarantee, and you're in one of those states that follows those rules, then your spouse's wealth, their assets, are not subject to the personal guarantee that the franchisee signed, right? So it can be a very important thing. It can help protect one spouse's assets or wealth should they have anything that's separate, right? So that's the context around it. Franchise agreements typically are going to be signed already by an entity. So the entity, then LLC or corporation, is going to be the franchisee, and then the ownership of that entity is going to sign a personal guarantee. Most of the time, I'll tell you, husband and wife teams will sign it together. They will sign personal guarantees together because they're both going to be involved in it. Sometimes that's not the case, and when that's not the case, the spousal guarantee topic comes up, and whether the franchisor is going to force the franchisee to have their spouse sign a personal guarantee or not. Some systems will not relent on it. That might be a deal breaker. Some systems will. Some systems will negotiate with you and not strictly require that. But it's something that you got to pay attention to and you got to understand. And you're going to have to do an analysis from your own state. It's not something that we can give you a generic answer that's going to always be the case. But if you are looking into how to protect yourself from personal guarantees and franchise agreements, call us first and we can chat with you a bit. The next step is going to be to chat with an estate planning attorney, frankly. An estate planning attorney or an asset protection planning attorney, someone who has experience in small businesses, and they can walk you through what options you have in your state to protect your wealth, whether that means setting up a trust, right, if you want to transfer wealth to the next generation, or maybe creating some offshore holdings if you want to maintain liquidity and be able to reach your assets, but make it very difficult for creditors. A lot of different options. Really depends on what you have and what you want done with it. But those estate planning attorneys, asset protection attorneys can walk you through what those options are that are specifically available to you and what might be best. So, I just want to give some color around spousal guarantees. We're not doing a treatise here, but just give me a little insight on it, important terms in the franchise agreement. So if we can help you read or review your FDD or your franchise agreement and help you understand those, reach out. That's what we do every day. And we love to chat with you. Until next time.